Welcome back to Business Equity and Opportunities. How safe are you when you go online on your business computer? Maybe not as safe as you think. We reached out to a cybersecurity expert to get a few practical pointers on how to better protect you and your company online.
This is Business Equity and Opportunities. Access to capital.
My name is David Hope. I am a media technology lawyer based in San Francisco and have practiced now for over 30 years. There's a whole range of lawsuits that are pending, some brought by private plaintiffs. Some 40 different attorneys general of different states have filed lawsuits against social media platforms. And we have also apparently quite a number of school districts also have lawsuits pending against social media companies. And all of these legal actions are based on this theory that social media is dangerous to youth due to its addictive properties. Well, I think there's a number of concerns that potentially could come from this litigation, and we're talking about over 1,000 lawsuits. Of course, all attention has been focused here in the last several days on the litigation pending against Facebook in Southern California and Los Angeles, the KGM case, the initials of the plaintiff. But there's a whole bunch of these at various stages of the pipeline. So the question is, if one of these or if a certain number of these cases reaches the conclusion that social media companies, that the platforms are creating an unreasonably dangerous product by making these platforms, engineering the feed and so forth in such a way that it causes users to come back and to spend a lot of time on the platform. What are the implications of that for other media, such as video games? Even platforms like Netflix, let's say. So there's potentially, or even, e-commerce platforms, you could say, like Amazon. There's potentially far-reaching implications that could come from this litigation. Social media obviously has been around for a long time. There has not been any recent legal developments, certainly no laws at the federal level. Now, at the state level, of course, some states have been considering legislation that could hold social media companies responsible for different types of harms. I don't think there's a clear answer as to why we now have all these lawsuits pending. Obviously, this has been a matter of public concern, and this could be just part of the zeitgeist that plaintiffs' lawyers saw an opportunity to, in the cultural climate where these actions were likely to be more successful. And, we certainly have seen, just more broadly speaking, even in the last 10 years, we certainly have seen, I think, a broader kind of, we've moved from sort of a fascination with technology in many ways to sort of, in particular, consumer technologies such as social media. And you could name other categories as well, sort of a fascination to, let's say, a skepticism, and certainly in some quarters a downright hostility now towards technology as we're seeing it manifested today in social media and in some other products and services. So fundamentally, the concern is, are we going to have a court decision that effectively holds that business owners like your viewers who have online services could somehow be held liable for making their online services especially compelling? Meaning that people really just want to view that content, they want to interact with that content, day after day. And that, of course, is the case with all sorts of online services. In particular, let's say video games is probably the next category to come after social media. Should someone be held responsible for the fact that people find that content compelling and continue to tune in, perhaps even they are addicted to that content. And I don't want to suggest that the claims that are being brought here in these social media cases involving teens and younger kids as well, that there hasn't been real harm that's suffered there, and that there ought, and that I don't want to suggest that there ought not to be some sort of regulation or some sort of responsibility on the part of platforms that intentionally are directing these algorithms towards children. But it does become quite difficult to draw the line at some point. And fundamentally, these lawsuits are not contingent on the subjects being children, because we don't actually have in the U.S., we don't have any laws that the plaintiffs' lawyers can use to reach this conclusion that a product that's made especially interesting that children really want to engage with, that is illegal. It's not illegal. Having said that, no one's going to deny, I think, that there is real harm that is being that has been at least related to large-scale social media use by children. So it's a challenging situation, and really it's one I would say that is not appropriate for a court. It's appropriate for the U.S. Congress, perhaps state legislatures, to figure out what the balance is and how this problem ought to be addressed. But here we are. It is in multiple courts across the country. Certainly in the realm of privacy, this is one area where the U.S. has taken a leading role. We have this law called COPPA, Children's Online Privacy Protection Act, which has been around for 10 plus years now. And in recent years, we've had similar but more comprehensive laws at the state level in California and other states. And so we have drawn a line in terms of collection of personal information and use of personal information between children who we have as a society, judged that they don't have the analytical skills, they don't have the ability to make an informed decision concerning their personal information. And so we require that parents, under the COPPA law, parents have to consent to the collection of that information. It would be possible, and again, I think this is a question for a legislature and not for a court, but it certainly would be possible to draw a line and say if users are under a certain age, then algorithmic methods of engaging them and maintaining their attention can't be used, or perhaps can't be used without parental consent, or can be used only to a certain extent. So it would be possible to draw that distinction between underage and adults who, at least in theory, ought to be able to decide for themselves whether they are going to pick up the phone and scroll through social media. In reality, we see that these addictive properties tend to apply across all age groups, but at a certain point, I think it's reasonable to say that it's up to the individual if they want to, subject themselves potentially to addiction. Well, I would think for your audience who are running online businesses, particularly content-based businesses, interactive businesses, the concern really is going to be what kind of line, assuming that, these rulings come out in favor of the plaintiffs to some extent anyway, and that's not at all a foregone conclusion. These are not simple cases. As I said, there's no law that they can directly point to that says, hey, you violated this statute. Instead, they have to build their case around product liability for the most part. Product liability laws, which were drafted to address, things like, a product you buy at Home Depot, whether it has the appropriate protection, so your eyes aren't damaged, or, or children's toys, they're safe for use by the children. Product liability laws were not written with online services in mind. And so this is a challenge for the plaintiffs' lawyers. And so the question is going to be if one of these courts, and frankly, with all the number of lawsuits that are pending, it would be surprising if at least one of these cases didn't go up in favor of the plaintiffs. The question is going to be, how did the court thread that needle and what are the implications for other online businesses. And so, yeah, I would say that we'll really have to wait and see kind of how this evolves.
Up next, Transit Equity Day is coming up on Wednesday. Find out what the Indigo Foundation has planned for the celebration.